Cannabis is legal in Canada, and that brings with it a whole host of challenges, both for people who want to recreationally use it and people who use it medicinally. I've invited Jon Danyliw. He's an employment and labor relations lawyer with Miller Thomson to give us some insight in terms of the responsibilities on the employer and employee as we go forward with some of the legislation that's just been brought about on us here. So, Jon, welcome to the show.
Great. Thanks for having me.
I want to talk a little bit about you and how you got involved with the labor and employment aspect of law and then how that dovetails into the new legislation with cannabis.
Right. Well, I've been practicing in the area of labor and employment law for probably about a decade or so. And obviously right now the big hot topic and the thing that a lot of employers in particular are concerned about and have questions about is legalized cannabis, and what does that mean for their workplaces?
What does that mean then? If we're going to look at, we're familiar with alcohol, and maybe it's said that what you can do with alcohol as opposed to what you can't do with cannabis. What are the differences between the two?
Right. Well, first of all, I'll talk about some of the similarities. Even though cannabis is now legal for recreational use, obviously that still doesn't give an employee or any worker the right to show up to the workplace impaired. So in that way, it's the same as alcohol. You wouldn't expect somebody to bring a beer with their lunch to the office. So similarly, on somebody's smoke break, you don't expect them to go out and smoke a joint. So in that way, it's similar to alcohol. The big difference, however, is with how you detect impairment and how you can test for impairment, and really the lingering effects of marijuana on somebody, and whether even after the high has worn off, there's still some level of impairment there. And I think that's really the big concern here.
I'd imagine that has to come into play with employees who are working for, I'm going to use construction as an example. Mm-hmm. If there's someone building a deck, for example, and instead of every 16 inches, they go every 24 inches on center. Are there liabilities with default in construction, and mm-hmm. does that come back to the company, or does it flow through to the employee?
Right. I think in that situation, if a job just isn't finished properly and there's issues with the construction, that ultimately is going to come back to the company, because it's the company who has contracted with the customer to build a certain thing. And of course, when you're building a building or something like that, part of the deal is, it's going to meet all building codes and things like that. So there's potential liability there if the employees are on site and if somebody's impaired and simply makes a mistake. But I think for employers, the biggest concern is really the individual's safety and the safety of the other folks who are on that same job site with this person. That seems to be the biggest concern that I've seen raised by employers.
So it's not just so easy to say, well, at my company, we're going to have a zero tolerance policy. It's got to be a little more involved and in-depth than that.
Yes. I mean, let's talk about policies in general. First of all, an employer's drug and alcohol policy or fitness for duty policy, or whatever you'd like to call it, that's really going to set out all of the expectations on employees, supervisors, managers, and it's going to set out what everybody's roles are in dealing with this whole process. Somebody who's more in a management role may be responsible for making sure that the policy's up to date and communicated to people. A supervisor is going to be making sure that, the policy is followed by everybody that they're supervising, and then individual employees have an obligation, typically under these policies, to comply with the policy and make sure that they're doing everything they're supposed to. Now, you mentioned zero tolerance policies, and while there can be zero tolerance for impairment in the workplace, where we see people get into issues is where it's a zero tolerance policy in terms of if you come to work high, you're fired. It's that sort of zero tolerance, that immediate dismissal or immediate discipline without any further investigation. That
How
really
high? I mean, if you're kind of high or really high, or
well, obviously the circumstances of the case are going to change what you do, but really there has to be some flexibility built into the policies to say, this is what's going to happen if we suspect you're impaired. These are the steps that are going to occur. So it might start with, okay, if somebody is suspected to be impaired at work, perhaps the supervisor reports it to the manager, and then they take that person, off their duties immediately, because obviously it's a safety issue. And then perhaps they have an interview with the individual to see, okay, what is going on with this person? Because at that point in time, we may suspect impairment by drugs, but it's important to actually do more investigation and see if that employee has some other reason that they might be showing, symptoms of what might look like impairment by drugs.
So this is speaking technically with recreational use. Is there a difference between what's taken medicinally versus recreationally?
Yes and no. Now, of course, if somebody is taking it medicinally, if they have proper authorization to use it to treat something, then that has to be accommodated to the extent possible by an employer, just like anything else related to someone's disability. And I should add at this point that dependency on a substance is also under the law considered to be a disability. So if an employee was to come forward and say, look, I think I have a problem with drugs or alcohol or any substance like that, then obviously the employer is required to accommodate that as well to the extent that they can. So we have the sort of accommodation side of things. And then on the other side, we have, can you be impaired at work? And whether it's medicinal or recreational, the answer is still no.
So the key word there is impairment, I'm hearing.
Exactly right, yeah. It's the impairment in the workplace that's the issue.
So when we look at the responsibility is not solely with the employer. I mean, there has to be guidelines. This is a playing field. We're going to play. These are the rules. Are there any obligations on behalf of the employee to, if there is a 24-hour limit that you must stop between when you last consume and when you show up for work? Mm-hmm. Again, I guess that's coming back to a policy more so than it is the onus on the employee.
Yeah, I think there's two things there. Under our occupational health and safety legislation, obviously employers have a duty to provide a safe workplace for their employees, but workers under that legislation have a similar duty to ensure that they're not engaging in any unsafe activity at work and putting anybody else in jeopardy. So obviously that would include coming to work impaired. So that's the legislation which does put a duty on employees to make sure that they're working in a safe manner. And then we've got sort of, let's call it the employer's policy side as well, and what the employer's putting in place to say, this is what we expect of you, and these are the behaviors we expect, and this is what we say you can and can't do before you show up to work. Now, legally, an employer can't tell an employee what they can do in their own personal time when they're not working, but if what they're doing in their personal time is going to impact their ability to come to work and perform their job properly and safely, then I think the employer does have an ability to sort of say, this is what we expect of you. We expect that you're going to come to work fit for duty and ready to do your job safely. And if that means our expectation is you're not going to use cannabis for a certain period of time before your next scheduled shift, I think an employer is certainly justified in setting out that kind of guideline.
I guess we're getting into a little bit of gray territory as we move forward, and it'll be a learned thing as we go on. I guess I'm wondering, when it comes to, we understand that there may be up to 28 days of residual, I call it debris, but traces of the CBD or the THC in the bloodstream. You're not technically impaired, but you do have it in your system.
Right.
Is there, if I was driving a school bus or public transport, is that again coming back to policies and procedures with the employer, that there may be 10 hours with this employer, but 24 with that employer?
Yeah, and I think particularly in industries you've mentioned, transportation, transit services, things like that. Obviously, those industries are very sensitive to these things because, if somebody's driving around a school bus full of children, you want to make sure that they're going to be safe. And what you mentioned earlier about the THC remaining in the body for a period of time afterward, that's really one of the issues that causes a lot of the difficulty, specifically with cannabis, because what that means is we can only test for whether it's in your system, not whether you're impaired. Current testing, it's not like a breathalyzer where you get a reading and you can say, okay, based on these numbers,
Sure.
you're impaired.
Yep.
What we get is, this is how much is in your bloodstream, but what does that actually tell us? Well, it really just tells us that this person has, and based on the amounts that are seen, you can kind of maybe guesstimate when they might have used, but it really depends on how often they use. Their own physiology can affect it. So you can't tell that, okay, somebody used it 8 hours ago, somebody used it yesterday, somebody used it half an hour ago and is high right now. Unfortunately, the testing doesn't give that information.
If people are watching and they may be an employee or they may own a business or several in charge of managers or supervisors, where would you guide them in terms of getting accurate information for their business or for the job that they go to? Where would you send them or include some place for them to get that information accurately?
Yeah, I mean, there are some good resources online. I believe the Canadian Centre of Occupational Health, if I'm saying that correctly, they've got some good resources on their website. Health Canada as well has some good information. But that's going to be general information. What I would really recommend that employers do if they have questions, concerns, or if they're just not sure their policies are good enough right now, would be to consult a labor and employment lawyer and get the specific help that they need for their specific workplace. That would be my recommendation.
Awesome. John, I want to thank you for taking that time and shedding some light on that. I wish you the best of success in these coming months and this new legislation. And I guess moderation is the key, but appreciate your time today.
Great. Thank you.
We'll be right back.